see if I can find a caption. Please.
And I'm sorry, doctor, I'm having trouble hearing.
Yeah, it's the microphone was off, and now I think. Can we put it down a little? It's too loud. Again, this is the open session of the Panel B of Medical Board of California. My name is Dave Ganadev, and I will have the board members introduce themselves for the sake of the court reporters. Dr. Levine.
Sharon Levine,
Howard Crouch.
Denise Pines, Michelle Bollard.
Thank you. Judge Benjamin will run the meeting, the rest of the meeting. Thank you.
Good morning. I'm going to open the record before Panel B of the Medical Board of California in the matter of the statement of issues against Sheila Nasi. This case bears agency number 2013-234-138. Today is July 30th, 2015. It's almost 9:30 in the morning. We're in Burlingame. This is the date, time, and place set for oral argument in this matter. My name is David Benjamin. I'm an administrative law judge for the Office of Administrative Hearings. I've been assigned to conduct the hearing in this matter today. May I take the appearances, please, beginning first for the Attorney General's office.
Good morning. My name is Josh Tomplay, Deputy Attorney General, representing complainant today.
Good morning.
Good morning, Your Honor, and members of the board. I'm Gary Wittenberg, and I represent the applicant, Dr. Sheila Nasi.
And that's Dr. Nasi sitting next to you.
That's correct, Your Honor.
Good morning to both of you. The purpose of this hearing is to give the parties the opportunity to present oral argument on how this matter should be resolved. It's my understanding there was a proposed decision that was issued after an administrative hearing. That decision was non-adopted, and the matter is now before the medical board to decide the matter. The medical board's procedures call for each party to have a certain amount of time to present a closing argument, beginning first with the applicant or the respondent, Dr. Nasi, then the Attorney General's office, and then one more round. The first round for each of you is 15 minutes. The second round is 5 minutes. The board's regulations also allow the applicant an opportunity to speak to the board. It's my understanding from talking to counsel before the hearing that Dr. Nasi wants to take advantage of that opportunity at the close of the attorney's arguments, and that she will take about 5 minutes to do that. And I understand that's acceptable to both parties. Is that right?
That's correct.
Okay. As I said, the purpose of the hearing is to hear argument. This is not the time to present new evidence. All of the argument has to be based on evidence that's already in the record. And the same holds true for Dr. Nasi's statements. Her statements need to be confined to matters that were that are already established in the record. The board's procedures require me to swear Dr. Nasi in when she speaks, and I will do that, but still the overarching obligation is to stay within the record. So having said all that, we begin with counsel for the applicant, Mr. Wood.
Thank you, Your Honor. The only allegation contained in the statement of issues and the only cause for discipline in the proposed decision is that Dr. Nasi suffers from a physical or mental illness affecting her competency pursuant to Business and Professions Code Section 822. That section requires a finding that the applicant is currently suffering from a physical or mental illness affecting competency. This record is clear that Dr. Nasi is not currently suffering from a mental or physical illness affecting competency. Dr. Nasi experienced significant fatigue and depression during her residency program at USC, which did affect her performance. Throughout residency, she was followed by a psychiatrist, Dr. Bitar, who she was referred to by the residency program, who diagnosed Dr. Nasi with major depressive disorder and placed her on multiple trials of various antidepressants, none of which were effective and many of which had terrible side effects. She saw many other specialists to no avail to address the depression and the fatigue that she had been experiencing during residency. And although she successfully completed 2 years of residency as required for licensure, Los Angeles County USC residency program placed her on probation at the end of her second year in 2010, and they didn't renew her contract to return for year 3. After she left the program in February of 2013, after she resecured insurance, she continued her quest to find answers and to determine what the cause of her medical problems were. She found Dr. Amy Ben-Artsy, a board-certified rheumatologist, who diagnosed her with lupus, and Dr. Bitar subsequently revised his diagnosis of major depressive disorder from major depressive disorder to depressive disorder currently in remission caused by a medical condition, namely the lupus. The board had Dr. Nasi evaluated by its expert psychiatrist, Dr. Shipko, back in June of 2013 while considering her application. Psychiatrist Dr. Shipko was the only witness to testify on behalf of the board at the hearing. Dr. Shipko wrote in his report and testified at the hearing consistently. His report in 2013, his testimony in 2015, that Dr. Nasi has, quote, no psychiatric diagnosis, and that Dr. Nasi, quote, is not currently suffering from any symptoms of an identifiable mental illness. He observed no signs of anxiety or depression during his evaluation. The MMP scales for depression and anxiety were all within the normal range. In fact, Dr. Shipko wrote in his report, Exhibit 29 on page 23, severe fatigue related to yet undiagnosed lupus is a reasonable explanation for the sharp and serious decline in her work in the months prior to going on probation and taking her medical leave of absence. The fatigue was based on difficult to diagnose physical conditions and not primarily on emotional symptoms. The fatigue which impaired her functioning is reportedly improved to a significant degree at the present time with prednisone. Dr. Shipko, in fact, opined that Dr. Nasi's undiagnosed and untreated lupus was a significant factor in a reasonable explanation for the performance, her performance during residency. Dr. Annette Swain is a neuropsychologist. She also testified at the hearing. You may not be aware of Dr. Swain's opinion because the administrative law judge neglected to include any reference to Dr. Swain's testimony or her 39-page evaluation report in the proposed decision. Dr. Swain evaluates professionals with medical conditions to determine if they are neuropsychologically or psychologically impaired to practice their profession. She performed a comprehensive evaluation over a 2-day period, did a full battery of psychological and neuropsychological tests, spent about 8 or 9 hours face-to-face with Dr. Nassih, and testified that Dr. Nassih tested in the superior range in almost all domains and above average or highly above average in all of the rest. She found no evidence of any condition that would impair Dr. Nassih's ability to practice medicine safely and competently. She also noted that in reviewing the performance evaluations at County USC, that Dr. Nassih did not receive any unsatisfactory reviews from her attending physicians during her 27 and a half months in the program. She received 4 low satisfactory performance reviews, and Dr. Swain noted that each of those 4 low satisfactory reviews by an attending physician related to rotations in which Dr. Nassih was on overnight call and was sleep deprived during this period of time that she was suffering from lupus, which had not yet been diagnosed and which went untreated. Now, notwithstanding, Dr. Swain concludes that she found no evidence of any condition that would impair Dr. Nassih's ability to practice medicine safely and competently. Notwithstanding this consistent and uncontroverted evidence, the complainant continues to raise the specter that Dr. Nassih has some underlying mental issues that warrant a restricted license. And I don't have the time to go through each and every factually incorrect statement, but I do want to point out 1 or 2. Complainant argues in their brief that Dr. Nassih's withdrawal from medical school at Albert Einstein, for instance, was somehow connected to mental illness. This is absolutely untrue. Dr. Shipko reviewed the records from Albert Einstein. He interviewed Dr. Nassih extensively concerning Albert Einstein. It's all reflected in Exhibit 29. And he concluded, he testified at the hearing, quote, "I did not feel it was part of any pattern I needed to look at." He wrote in his report that I took into consideration the events that took place at Albert Einstein and do not feel that these events are part of any pattern and that it represented a misunderstanding between Dr. Nassih as to whether she was supposed to attend or should have attended a particular committee meeting. No relationship whatsoever to mental illness. There are other instances in the brief. There's reference to Dr. Nassih, that Dr. Nassih conceded at the hearing that her depression contributed to her withdrawal from medical school. Again, not true. That's not in the record. Complainant cites to a particular passage in the transcript to support this conclusion, and when we go to that line and page 177, lines 11 through 20, cited by the complainant, the question is, regarding your leave of absence from the residency program, not the medical school, from the residency program, are you aware that your physician, Dr. Sachs, reports in her letter that among the reasons for leaving that program, the residency program, was your depression? And Dr. Nassih acknowledged, yes, that was the case. but not that there was a problem with depression that caused her to withdraw from medical school. Untrue. There's reference to Dr. Nassih being in psychotherapy for long periods of time and related to depression, and as it turns out, the references to an LCSW that Dr. Nassih saw after she left medical school, and as Dr. Nassih testified, the purpose of that therapy was to see where her heart was, whether her heart was in terms of whether she wanted to re-enter medical school, and that the therapy helped her to make that life choice to re-enter medical school and pursue her passion. Not related to some underlying mental illness and depression. It's untrue and misleading to suggest that Dr. Nassih has some underlying mental illness. And then finally, there's the statement at page 3, lines 20 to 22, where a complainant argues that Dr. Swain, a mere neuropsychologist, is the only expert to testify that Dr. Nassih's history of depression could be explained by lupus. And again, that's untrue, because Dr. Ben-Artzi, the only rheumatologist to testify at the hearing, also testified that that her history of depression could be explained by the lupus. In fact, in the transcript at page 32, the court, the ALJ, asked Dr. Ben-Artzi, quote, "Were you able to form an opinion as to whether Dr. Nassih's report of depression was due to lupus? Was that a factor?" Dr. Ben-Artzi responded, quote, "It was most likely due to lupus." Dr. Shipko testified that he would defer to a rheumatologist to opine on issues related to Dr. Nassih's prognosis and treatment and diagnosis. Dr. Ben-Artzi, again, board-certified rheumatologist, fellowship trained at NYU, and the only rheumatologist to testify. The proposed decision is virtually silent on Dr. Ben-Artzi's opinion and testimony. And also, there's no mention of Dr. Swain's testimony or opinion at all, not mentioned, not one breath of it in the opinion. Dr. Ben-Artzi opined that the severe fatigue and depression that Dr. Nassih experienced during residency was in fact caused by the undiagnosed and untreated lupus. In fact, the administrative law judge in the proposed decision at page 5, paragraph 22, cites to that.
Counsel, you have 3 minutes.
I'm sorry?
3 minutes.
Less than a month after, before the hearing, Dr. Nassih's lab results indicated that there were no signs of lupus activity. According to Dr. Ben-Artzi, she currently has mild lupus that is well controlled with low doses of prednisone. Her only symptom is mild occasional fatigue, similar to what a doctor might experience if he didn't sleep well the night before. Dr. Ben-Artzi's opinion was that lupus does not impair Dr. Nassih's ability to practice medicine competently and safely. It is established in this record that the difficulties that she had in her program were related to the undiagnosed and untreated lupus. The impairment that existed in 2009 no longer exists. That's clear on the record. The proposed factual finding and supporting discipline does not establish that Dr. Nassih suffers from a current physical or mental illness that affects competency. And then just so crucial to point out that during residency, Dr. Nassih completed 27 and a half months. Exhibit D, Dr. Lagomasino, her program director, submitted an email to the board stating that she was given credit for 27 and a half months of satisfactory postgraduate training. Dr. Lagomasino signed under penalty of perjury and submitted to the board Form L3B as part of the application, stating that Dr. Nassih, quote, has acquired the skill and qualifications necessary to assume the unrestricted practice of medicine in this state. And that was before she was diagnosed and before she received the treatment for the condition that was the cause of the deficiencies that occurred during her residency program. The board's decision must be based on the administrative record. Dr. Shipko, Dr. Swain, Dr. Vitar all agree that Dr. Nassih does not have a mental illness. Once she was diagnosed and treated for lupus, her depression ended and her fatigue improved significantly. These facts are not in dispute. Dr. Shipko defers to a rheumatologist regarding the lupus, and Dr. Benartzi, the only rheumatologist to testify, has opined that the lupus was responsible for the fatigue and the depression, and it's now under control and that she's safe to practice. The order of non-adoption asks whether the proposed penalty should be modified on this record. And on this record, there is no basis for a restricted license. Dr. Nassih should be finally awarded, issued her license. She initially applied for that license in December of 2011 is when this battle has been going on since. Thank you.
Thank you. Any questions for council at this point? Mr. Tomplay.
Good morning, Chairman and members of the board. I have very little to add to the written argument that I prepared today. I'm just going to summarize a few points briefly. But first,
Let me interrupt. So the packet I got didn't include written argument from either one of you. Did the board members get written argument? No. My packet said that no written arguments were received from respondent or from the Attorney General.
We submitted written argument 2 days before the deadline, Your Honor, by Federal Express.
could we take a brief recess?
Yes. Let's go off the record. Let's figure out what happened and what we're going to do about it.
No, it's minus 15 pages. This is 6 pages. Yeah.
I don't think we're gonna get away with that.
Going to go in 15-20 minutes this recess. While he has to read through the written brief, unfortunately, this going to submission so it has to be basic and what he did. Because we didn't read it as that's what I said, but Jen said that. That's okay.
I think that's fair.
So should we go back to the
Angel, are you okay to go back on the record? It's all right. Okay, we're back on the record after a short break. And what I'd like to do is recite for everyone what I've learned and done during the break, and then I'll give counsel a chance to correct me if I've said anything wrong. So both the applicant and the Attorney General did submit briefs to the board. Those briefs were not copied and distributed to the board before the hearing opened this morning. They're being copied now and they'll be distributed to the board members. The plan that I have discussed with council and that I believe council will agree with is that we'll take a break of about 20 to 30 minutes to afford board members the opportunity to read the briefs, and then we'll reconvene. We'll start again with the applicant, but we'd like the applicant to streamline his first round of argument in view of the fact that the board did hear everything that you said, Mr. Wittenberg, although it didn't have the opportunity to read your argument before hearing what you said. We'll come back, we'll start with you, then we'll go to Mr. Tom Play, and then we'll do the second round and comments from Dr. Nasi. So first of all, let me ask if that's acceptable to both of you and if it's accurate. Mr. Wittenberg?
Yes.
Yes, thank you.
And with the board, is that acceptable to the board?
Yes.
Okay. So then we'll go off the record now. Those copies should be coming in at any minute, and the board will then take a recess and review the briefs.
When are we reconvening, Your Honor?
Well, it's almost 10 o'clock. I would think that the copies are going to be distributed at any minute now. Should we say not before 10:20? It may be later than that if it takes longer to review them, but not before 10:20? Thank you.